I'm glad you asked that, Chef. Nobody's really asking on the ground as a person.
The Fifth Amendment of the Constitution protects him from speaking.
Hello, my name is David Bruno. I'm with the former Morris County prosecutor, Bob Bianchi. And we are partners at the Bianchi Law Group, located in Parsippany, New Jersey. We are former prosecutors who aggressively fight the government when our clients are charged with crimes. We're going to be talking about the new bail process, which is also the detention process. And it was revamped a couple years ago, and it's critical to people that are charged, friends, family, and even defendants. When somebody is arrested, the procedure has changed. Bob, talk about the changes generally.
You know, we get calls by potential new clients all the time that have after they tell you the story, we want to do a deep dive at the Bianchi Law Group, just like we did when we were prosecutors. We handle things very similarly in our defense practice with our policies and procedures. So we really want to know a lot and give a lot of information to a client. And after there's an agreement to enter into a relationship, a client will always ask you, like, well, what's next? Typically speaking, what's next is you sign a retainer agreement, payments are made. But as far as the judicial system is concerned, which is the most pressing thing on their mind, is this first appearance / detention hearing. Now, when I started practicing law, all the way up until, as Dave indicated, a couple of years ago, the detention hearings, if you will, were called bail hearings, and it was a cash bail system. So if the judge would assess your background and whether you failed to appear, and even though you're presumed innocent, the fact of the matter was, back in the day, the seriousness of the offense certainly would be taken into consideration, one, because it could increase your flight risk, but two, because of the seriousness of the offense. The problem that I encountered when I became the head county prosecutor was I remember getting a list of the jail cases, Dave, and we were in shock that there were people that were waiting for low-level offenses like a minor theft of a couple of $100 for 2+ years waiting for their trial because they couldn't make $100 or $200 bail. And even as a prosecutor, we felt that was outrageous. They spent more time in the county jail waiting for trial by far than any sentence they possibly would have gotten had they been convicted and a judge was inclined to put the person in jail in the first place. So, of course, we moved to get those people out as quickly as possible because we didn't think that was a fair thing to do. And eventually the legislature came along. And what happens essentially is within this 48-hour period now of being arrested, our clients want to know, and the people that call us, well, what occurs next? And what happens essentially is the prosecutor is going to make a determination as to whether or not they want to seek detention. It's no longer based on a monetary bail. Dave will speak to you about that in a second, but rather whether they want to seek detention. And if they do seek detention, then you're going to have a detention hearing within that 48 hours. If they don't, then you're just going to have your first appearance. And a lot of people get very nervous about the first appearance. So let me explain something to you. You will be shockingly surprised at how painless it is. It's essentially the judge indicating what the charges are. There's a discussion about whether discovery is being exchanged. There's sometimes an entry of a plea of not guilty. It's just basically a first appearance to start the process going forward. But if there's going to be an application by the prosecutor to detain you, I'll say this as my last point as a criminal trial attorney now, defense attorney, it becomes so much more difficult to effectively represent a defendant who is in jail by mere fact that you don't have access to them. And in COVID, you have even less access than you had before. It's difficult to bring them documents, to give them discovery, to have them review computers and phones and things of that nature. So getting a client out on at the detention stage so that they can assist in their defense is a critical thing. And I think what New Jersey did and the way they did it with regard to ensuring public safety, ensuring the appearance of a defendant, but also discharging many people from the county jail. So you weren't waiting. Hey, Dave, you remember when I came into office, there were some cases that we had, folks, I am not making this up. Now, they were serious cases, but some of them were waiting for 9 years in the county jail waiting for their day in court. You know, there's a thing that we call the Speedy Trial law. It's in the Constitution. I'm sure I read it somewhere, but it was kind of shocking that was the way the cash bail system was working at the time. Dave?
Yeah, that's how it was, and we've completely shifted away from money. And like Bob said, I mean, it doesn't matter how much money you have. If the complaint, the criminal complaint that you're charged with is put on a warrant complaint, That's the alternative is a summons, and the summons, you just get a date to appear in court. It'll be a Zoom hearing. You go home. There's no detention. But if it's on a warrant complaint, you will go to the county jail. It doesn't matter who you are, how much money you have. Warrant complaint equals detention for at least 2 days. You should have a first appearance within 48 hours. And it's at that time where the prosecutor has to make that decision. Because if the prosecutor feels that the defendant should be detained, they have to file a detention motion, and that first appearance is essentially setting the detention hearing up. If the prosecutor does not file for detention, and that's what we try to do, we try to jump in early, get on the phone with those prosecutors before that first appearance. I could tell you just this year, I had a case where the prosecutor filed for detention. Within that 48-hour period, I was able to get on the phone with them and change that decision so that the client was released on conditions. And that's ultimately the goal, not to have a detention hearing, because if we could convince the prosecutor in that short 48-hour window to release on conditions, then we could do it by consent and we don't have to go to the hearing. But for those cases where the prosecutor does file for detention at that first appearance, we will have to prepare for a hearing, and that happens very, very soon, usually within 5 days. And we have discovery that we're entitled to that we wouldn't have gotten if it was a regular case very early on. And we have to prepare the case for presentation to convince the judge that there are a series of conditions that are available to the court, such as calling in, appearing at the courthouse, house arrest, maybe GPS monitoring. There is a long list of possible conditions. And the goal is to convince the judge that there are a series of conditions that will assure the defendant's presence, protect society, and also prevent obstruction of justice. Those are the 3 things that the courts are looking for in the detention hearings. So this is a hurry up and go. It's different in every single county. There are 21 counties throughout the state of New Jersey, different process. I mean, generally speaking, it's the same, but when you have to try to get on the phone with prosecutors, try to get into contact with your clients at the jail, I mean, there are 1,000 other things that you have to be worried about. But certainly we're up on it. We follow it. We lecture to other lawyers on this topic. And we're certainly here if you or a loved one have to have a detention hearing. Bob, wrap it up.
Yeah, well, to our, we have a lot of law students that watch us on the media or these informational things that we put on our website at the Bianchi Law Group. And one of the other practical effects of this change in this law, I'll say, is that if prosecutors are disincentivized to just merely seek detention in every case, because if they do succeed in getting detention, speedy trial rights are now triggered, under the law, which requires them, no, you can't wait 3-4 years to try that case. You are now on a very short timeline. So they're much more judicious in making a decision as it being the most serious cases they seek detention. And lastly, David, this is big. Prosecutors don't have to give us a lot of information in the beginning of a case, but if they're seeking detention, they're required to give us a lot more information than we typically would get. And why is that important? Because it gives us a better idea of what the prosecutor's case is, which gives us a better opportunity to defend it.
Yeah, great point. I mean, generally speaking, prosecutors don't have to give defense attorneys discovery until either an arraignment after the case has been presented to a grand jury, or if there's a plea offer made in the pre-indictment stage. So this will guarantee certainly some discovery exchange. There are various different appellate division cases that come out interpreting this law and procedure all the time, and we're up on it. So also, Bob, just last point, great thing you said about speedy trial, because what we are seeing right now, we are filming this on November 9th of 2020, and we are in the midst of COVID still. And the courthouses aren't even open yet. There are no jury trials going on right now. In fact, I was one of the last jury trials prior to the COVID quarantine in March in Union County on a sex assault case. And now we have defendants that are detained in the county jail, and they are going to need their cases addressed. So for those speedy trial rights, they're ticking, they're going to be adding up. And ultimately, there's going to be these detention hearings that are revisited, And the prosecutors are going to have to come up, and the courts are going to have to come up with some solution to really move these cases forward where there are people in jail and the courts are closed. Any final points before I wrap up here?
Now, COVID's changing a lot of things. Recently, New Jersey just released over 1,000 prisoners where they gave extra credits to them because of the difficulties that they faced while being in jail for COVID. What you're seeing, folks, is that the government is trying to find ways to strike a balance between justice and not letting people just hang out there and waiting. Unfortunately for the people right now, they're not getting credit towards their speedy trial rights. Speedy trial rights are very specific, maybe something that we're going to do another conversation on what it means. But nevertheless, having people waiting in jail for a significant period of time in order for them to have their day in court is just antithetical to the interests of justice and the Constitution of both New Jersey and the United States of America. Let's get to it. Let's try these cases.
Yeah, good point. There was a recent court order that came down from Judge Grant, who's head of the AOC, the Administrative Office of the Courts, setting a date certain where the speedy trial rights will kick in again. They have been suspended over COVID. So we're looking at that and we're following that closely as well. Thank you for watching. On behalf of Bob and myself, the Bianchi Law Group, we are former prosecutors who aggressively fight the government when our clients are charged with crimes. We handle criminal defense, domestic violence, and municipal court cases throughout the state of New Jersey. Thank you for watching. If you have any questions, call us at the office 24/7. Book a Calendly scheduled appointment, and you could be on the phone with either one of us. We'll give you guys our attention and we'll evaluate your case. Thanks for watching.